All right, let's get started. Senate Bill 4. We're secondary on this,
Yes,
and it's an emergency bill.
it is.
Tell me all about it.
Senate Bill 4, of course, as the chairman said, is an emergency bill. It prohibits a charitable organization from participating or intervening in a political campaign on behalf of or in opposition to a candidate for public office, including publication or distribution of statements. A violation of this is a civil penalty up to $5,000. Willful violations are subject to a 2-year revocation of of the exempt status under the income tax, sales and use tax, and property tax. The prohibition must be interpreted and applied in the same manner as the prohibition on political campaign activity under the IRS Code 501c3. And this was interpreted and applied by the Internal Revenue Service as of January of 2025. The bill is contingent on an action by the President of the U.S. or the IRS or change in federal law that prevents the enforcement of or nulls what's called the Johnson Amendment. And the Johnson Amendment is the 501c3 status. There were amendments to this.
Of course there were.
The amendments add private foundations to the provision of law related to the prohibition, exempts organizations under the Johnson Amendment prohibition from certain enforcement provisions. It strikes a provision that would have required submission of additional attestation with the registration statement of charitable organizations. So under this, the charities would be required to register. It strikes the penalty, and it requires the Secretary of State or the AG to attempt to enter into settlement agreements through mediation with a violator or with the actual nonprofit organization before assessing a penalty. The amendment also decreases the penalty, the $5,000 penalty, to up to $1,000 for each violation. And it allows the charitable organization, if they lose their tax exempt status, to reapply.
That was a lot for just, you can't do a contribution, right? Is that the bottom line?
That's the bottom line. You can't do a contribution.
If you're a nonprofit, you can't give money to anything, to any political candidate.
Correct. And it's basically keeping the status quo in the event that it seems that on the federal level, this is changing. In the event that this changes whether by court order or for some other reason, then this bill will take effect.
Okay.
Favorable as amended.
Any discussion? 6-4 with one excused. I don't know.
Let's see, I have it.
Can you tell us?
Yes.
Party line.
Well, except for one. He voted. So pretty
He
much.
is party line plus Watson voted against. Okay, all those in favor? Opposed? They're primary, so we don't have to deal with it. What? Yeah, all three of them.
Okay.
Yeah. 28.
Senate Bill 28 is the bill that would implement a binding arbitration process for state employees. You should have a reprint on your desks. There are a number of amendments. These are amendments referenced by or brought up in the testimony by USM, DBM, State Retirement, and then in some conversations had with the Attorney General's office. So going through the bill, turn to page 2, I'll kind of walk you through it. This provision here that's being added, this is just specifying what the governor has to include in the governor's budget submission to the General Assembly. On page 3, you have the scope of the entities to which that applies. Turning to page 4 is where we start some amendments. This would, here at the top, add an exclusion for higher ed. Generally, throughout the bill, higher ed is going to be excluded from the arbitration-related provisions and maintain their status quo for collective bargaining. There is, on page 4, one thing to note. So last year, there was a bill related to the bargaining process for BWI, Airport and Fire and Rescue. So that is unaffected in this bill. On page 4, you have provisions beginning here related to the election for arbitration for applicable parties. On page 5, you have additional provisions clarifying that this new subsection C now is applicable for higher ed since they're being excluded from the arbitration provisions. This language that's being struck is covered elsewhere earlier in the bill under section 7108, as well as the BWI provision being stricken here. Their process is provided under subsection D, which is on page 6. Turning to page 7, further consistent language related to higher ed. And then here at the bottom, just some clarifying changes, clarifying that the General Assembly's legislative authority over both law and the budget is not being affected by binding arbitration. So the process is about the units and the executive. The General Assembly still has control over anything that's established in law or that is in the final budget. Similar on page 8, you have similar language there related to General Assembly's authority again. On the middle of page 8, you have provision here, section 3502, related to the scope of collective bargaining. In this new language being added, lines 21 through 22, State Retirement had proposed an amendment clarifying that the fringe benefits will be fringe benefits other than pension benefits. They had some concerns since the General Assembly is the plan sponsor and the plan is established in statute, and the General Assembly is not party to that bargaining process, to clarify that the pension plan is still the purview of the General Assembly as the plan sponsor. Again, here down at the bottom of page 8, further language clarifying the General Assembly's authority over changes in law. And then on page 9, you have the provisions outlining the arbitration process, starting on line 2, also with the clarification related to the higher ed exclusion. Continuing on page 10 and 11, provisions related to the arbitration process. On page 12, here after line 16 is some language requested by DBM specifying written arbitration award would include a statement detailing multi-year fiscal impact to the general fund. Again, on page 12, clarifying language related to the General Assembly's authority to control the law and final budget. And then beginning on page 13, you have, there's a change to the state constitution related to all this. And the applicable provisions you're gonna find on page 14. Again, there's a change here clarifying that these provisions are related to the budget submitted by the governor. You have conforming language related to the applicability of arbitration for higher ed. The changes in the middle, starting on page 14, lines 20 through 24. It's additional language. Again, these are requirements for what the governor submits to the General Assembly in the budget. Similar on further down lines 32 through 35. And then skipping to the end, on page 17, there's boilerplate language related to the constitutional provision and its statewide application. The constitutional change would go on the ballot, and then the ballot provision starts on the bottom of page 17, going on to age 18, just a clarifying change that this is about the budget submitted by the governor. And then at the end of the bill, you have provisions that the statutory changes in the bill are contingent on ratification of the constitutional amendment.
All right. First, on the amendments. Yes, Senator Corman.
Just question, just out of curiosity. How come, why is the system exempted? What was what's the thought behind
Well,
that?
I mean,
Not right, wrong, or different. I'm just
yeah.
curious about
There's a
them.
couple comments to that. One, last year, it was the bill that the House passed.
Right.
I think there was a sense that, given a number of things that have happened over the last couple of years, including requiring that they do the system-wide collective bargaining, was part of the component issues. Given the fact that I think they took a 8% cut last year in their budget, just a number of things, and just I think.
Okay.
That
No,
all
that's fine.
that all contributed to it.
Understood.
Other questions? Okay, so we're going to take a vote on the amendment, and the amendment removes the universities from the bill. Yes?
Yeah. Yes, it does that in addition to making the other clarifying changes related to the General Assembly's authority over law and the final budget, the DBM informational requirement for the arbitration award recommendations, and the state retirement clarification that fringe benefits do not include pension benefits.
Right.
So is that a separate amendment?
It's all in here.
Okay,
We're just going to vote on one amendment. But,
okay.
okay. All those in favor of the amendment, say aye. Aye. Opposed? Okay, we got that?
Yep.
One. Okay, now as amended, questions on the bill? Discussion? Okay, all those in favor, raise your hand.
Okay.
Yep. Opposed? Okay.
Yep.
All right. Thank you very much. So you absolutely can.
Yours.
Mr. Chair, I just want to say this is a long time coming. It's been in for several years. I'm always under the posture. We've done things like minimum wage. We've done things like paid sick leave. And I realize that you're not always going to get whole loaf, but a half a loaf isn't bad. So thank you.
Thank you. Yeah.
Can I offer one more amendment, adding myself as a co-sponsor?
If you like.
Is that okay, Senator McCrae?
Yes, sir. I'm going to ask
Oh, my man.
Are you the only one on the bill?
Senator McCrae is currently the only one on the bill.
Anybody else want to be on the bill?
Sure.
All right.
Chairman,
Yep.
I just want to make a comment.
Yep. Another comment over here.
So I'm obviously supportive of the bill, been supportive of the bill for a long time. Agree with the sponsor that sometimes you got a half loaf, but representing University of Maryland College Park as I do, I hope sooner rather than later we'll be able to extend this to higher ed. It's important. They're entitled to the same rights and benefits as other state employees, and I'd like to move in that direction when we can. Thank you.
Senator?
Yeah, let me just add, I mean, I just kind of think everybody should be, I mean, everybody, if we're going to do it for one, we should do it for all. So I kind of think the University of Maryland should be included in that, but it's better to, half a loaf is better than none.
Of course, Senator McCray will take that to the floor. Okay?
Finance secondary, so I'll get that over to them.
Yep. All right. 85.
Senate Bill 85 is a do-it departmental that authorizes revenues that accrue from resource sharing agreements to be used at the Secretary's discretion to support state-owned communication sites, communication facilities, and telecommunications equipment used in connection with resource sharing agreements, including program management for these activities. Just a little bit of a background. Resource sharing agreements are agreements between the state and, in this context, telecommunications companies to use state assets like land, towers, buildings, and then so the state receives money for those, and the telecommunications companies are able to use those land or towers. And right now, under law, the revenues that accrue from these agreements are able to be used for Maryland broadband and Maryland First, the public safety radio. So this would just add another use for those funds.
Senator Heatherly?
The fiscal note
I don't see it. I'm just-
had noted that that resource sharing agreement revenues account for a very small portion of the total in the IT investment fund. For RSA revenues totaled $738,247 in fiscal 2024.
No. Any other questions? All those in favor? Don't be too excited about this one. Is anyone opposed? Okay. I don't know. We'll see.
Is their budget like committee-wide, like it's not under any one subcommittee do its budget?
Don't you have it?
Do it's under EVA.
They have EBA. Okay. Nancy? All right, 193.
Senate Bill 193, this is the bill that would provide a sales and use tax exemption for construction materials and warehousing equipment used in the target redevelopment area of Washington County. There was an amendment, but it turns out we did not need to add that particular amendment to it. This bill passed unanimously last year, so it will go without the amendment.
Move favorable.
Wait a minute.
This was the one that had the amendment.
Always here for Mr. Chairman.
I know you are. All those in favor?
Aye.
Opposed? Okay. Senator Quarterman. Let's skip down to 312.
Senate Bill 312, this is the companion legislation related to the Governor's Salary Commission. This is implementing the commission's recommendations for the next term for the salaries for the Attorney General, Comptroller, Secretary of State, and State Treasurer. Yeah, it goes up. For the Attorney General, Comptroller, and Treasurer, the salary over the 4-year period increases by $10,000, and for Secretary of State increases by $8,000, and they're done in alternating years.
Okay. All those in favor?
Aye.
Opposed? Okay. I'll take that. I'll do that. And the next one.
Senate Bill 313, this is companion legislation from the Judicial Compensation Commission. It authorizes a annual stipend for the chief of the appellate court and a judge who serves as an administrative court for a circuit court or the district court.
I think as described, these folks have a lot of extra work. So this is a
Correct. Yeah.
little way to appreciate them. All those in favor? Aye. Opposed? Okay. Is this ready?
I think it is, but
You think it is?
No, it's not.
It's not. Okay. So we're holding this.
it's getting close.
Close, but not.
Okay. Why is it all your bills take so much?
These are cross files.
466.
Senate Bill 466 reduces the number of service hours from 100 to 90 to be eligible for the tax credit, which is $1,000. The bill allows medical students from other states that can train here in Maryland to participate in the program. And the preceptors are the trainers who train medical students. So these individuals will be allowed to have the credit. There is a technical amendment. You do not have it in front of you, but this amendment has been considered in the House as well. And the technical amendment would limit the access of the tax credit certificates that DHMH may carry forward.
Okay, as amended. All those in favor?
Aye.
Opposed? Sarah King.
Okay.
Let's go back to 231.
Senate Bill 231 is the departmental bill that you've heard previously. This bill is in reference to the slaughtering of horses, of racing horses in Maryland. The departmental bill prohibits a person from slaughtering or causing the slaughter of a racehorse for any commercial purpose. The bill was held in reference to whether or not an amendment needed to be added. However, the amendment was not added by the department.
So the concern was a trainer selling a horse at the end of the use of it to a third party, and then the third party getting it out of state and then getting rid of it, and the horse eventually making its way south of the border for slaughter. It's inhumane what they do to them. They put them on a trailer for 3 or 4 days, no food, no water, and they take them to Mexico and have them slaughtered. I worked with the department, and they feel that they have enough teeth in the bill to actually prevent that. So with that, I'd say I'm supportive of the bill, and we go forward with it.
Okay. All those in favor? Aye. Opposed? Sarah Jennings. Okay. 309.
Senate Bill 309 is, this bill exempts from the sales and use tax precious metal bullion and coins. In the 2025 BRFA, the sales and use tax, prior to that, the sales and use tax did not apply to precious metals. However, in the BRFA of 2025, a sales and use tax was imposed on sales of $1,000 or greater. And there was one exception, and that exception was sales occurring at the Baltimore Convention Center. And this bill would exempt all bullion sales from the sales and use tax.
So as you may recall, we had a lot of testimony from dealers and such saying that people just could cross the border. There was a potential loss for business, and that people, other than losing business for our own folks in the state, you know, it's just, they would just avoid us, essentially. So I asked staff to go and try to come up with some a better understanding from the dealers and others, and the results were?
I was able to obtain some data from some of the companies that came in to testify on reference to this bill. And in reference to their sale numbers prior to July 1, 2025, and their sale numbers afterwards, and the amount of tax they were collecting, the data that I've got is consistent, showing that the first half of 2025 for one dealer, the sales was 1.5 million. 6 months since taking effect of the law, their sales dropped to 300,000, a little over 300,000. And the sales that they collected in the past the sales tax that they've collected in the past 6 months turned out to be $1,023. And it was consistent. Another dealer, the sales tax collected, this particular dealer opened July 1, 2025. Sales tax collected was $390 from July to December, or July to January. Another dealer, their sales in July 2024 was 1.2 million versus their sales in July of 2025 at 645,000, and it goes on in that manner. Sales tax collected at another dealer after July, between July and now, $1,021.39.
I mean, so as far as I'm concerned, what's that? Well, I guess that's the simplest way to put it. So, all those in favor of the bill? Aye. Opposed? What's that? Oh, you want to be a sponsor? Yeah. Anybody want to be a co-sponsor?
There wasn't anyone on this side.
No, it's nobody over there. Corey and the other two. Okay. That's obviously Jennings. All right, let's go back to 518.
Senate Bill 518 creates the Maryland Financial Empowerment Center Network Pilot Program to establish a statewide network of financial empowerment centers in different regions of the state The Comptroller's Office is to implement and administer the program. Each center must provide free one-on-one financial counseling and coaching services on how to increase savings, pay down debt, access banking, and improve credit scores. The pilot program is set to sunset September 30th, 2029. The governor must include in the budget an appropriation to the Comptroller's Office in an amount sufficient to cover the cost of the program. And the Comptroller advises that the cost would be about $135,000.
Questions? All those in favor? Opposed? Senator King. Okay, 520.
All right, 520. Should remember, we talked about this one a couple times ago. 520 authorizes a charter county that has either a property tax revenue or rate limitation to set by a majority of the county council a property tax rate higher or collect more property tax revenues than authorized under the county charter for the sole purpose of funding the approved county public safety budget. Last time we talked about this, we had mentioned getting the approval from the different affected delegations. All except Prince George's County were okay with being included in the bill, so there will be an amendment to exempt Prince George's County from the bill. But Anne Arundel, Montgomery, Talbot, and Wycomico would all be included.
Okay, on the amendment to remove Prince George's, all those in favor? Aye. Aye. Opposed? On the bill as amended, all those in favor? Aye. Aye. Okay. Senator Roosevelt. Should get for causing trouble. 557.
Senate Bill 557 alters the definition of own, of the term own for the purposes of governing the operation of VLTs and the conduct of sports wagering. It changes the definition so that own does not include having a interest of 25% or less in the property or business of an applicant of a license. It doesn't include anything to do with voting rights or confer any voting rights, and the property has to be held directly by the person or held in trust. The testimony at the hearing was about individuals who were, there was transfer of property to them of a smaller interest, 25% or less, and they had to fill out disclosure forms and ethics forms because of it, and this would prevent them from having to fill out those forms.
Senator Hellman?
So I'm looking at the testimony and see that there's one particular group that this seems to apply to in terms of estate planning, et cetera. Do we know if this has larger ramifications for the larger companies?
I do not know, but I can look into it.
I just don't know. This seems like a pretty significant change, and I'm just wondering what the full ramifications are. But again, if it's narrowly tailored to this one, I don't have any problem with it. And I missed the hearing, I think, so that's why I didn't get to.
Okay, we're going to hold that. 558. We actually voted on this one before, right?
Yes.
We voted on this one before and had the, with the amendment as being in theory or in, and we now have it all settled out.
So you should have the amendment before you, and again, the amendment increases the allotted amount, the allocated amount to the program to $2.25 million. and requires DNR to administer.
All those in favor? Opposed? You good, Senator? Okay, Senator Bailey?
Thank you, Mr. Chair. I just wanted to say, obviously, as when we came here this year with this MOU, the MOU, we had been trying to negotiate this. It had been something that we've been going back and forth on since 1995, right? And I just wanted to recognize, obviously, Mr. Chair, and all of you who co-sponsored this bill to look at how important it was, and then the help that we got from, you know, all the people that came together, whether it was Department of Natural Resources, Chesapeake Bay Foundation, MDOT, the port, all the watermen who took their day off to come up here that day to testify and to show how important the health of the Chesapeake Bay and the oysters were, and then the port to recognize and be so supportive for the mitigation from dredging and keeping the port open. So I just wanted everyone to know how appreciative the people that make their living out there on the Chesapeake Bay and all the partners are, and I appreciate it. Thank you.
Thank you. 641.
$641 is a procurement bill. You previously discussed this at a voting session. This is the bill that would allow an exemption for Department of General Services, Department of Planning, Department of Housing and Community Development, and Department of Transportation from state procurement law requirements regarding negotiating or entering into agreements or partnerships with nonprofit entities for projects related to historic preservation, archaeology, or conservation service opportunities. At the prior voting session, there was some discussion about potential impact on labor and related to prevailing wage. So we do have an amendment, I think, sponsor of the bill is Senator Quarterman. You okay with that? We'll pass that around. And so on this amendment, as it's coming around, if you turn to page 2, it's just adding a provision saying except for a project subject to Title 17, Subtitle 2 of this article. And then the exemption applies as written. So that would mean if it's subject to the prevailing wage laws, then this exemption will not apply and it would still be subject to all the normal procurement processes.
Senator McCray?
Thank you. Mr. Chair, I just want to thank the bill sponsor for being able to figure out what does a middle look like. I think it still moves the needle and get them to some form of a goal, but it also protects folks that are on these state-funded projects. Thank you.
Very good. Good work, guys. All right, all those in favor as amended? Aye. Opposed? Okay. Excellent, excellent. Senator Quarterman. 647.
647, this is a pension bill, came out of the subcommittee. There is an amendment on your desk. The amendment includes one item adopted by the subcommittee, and then after the subcommittee voted, there was an additional provision that came up. What the bill would do is it would establish a new benefit tier for line of duty disabilities in the state police retirement system and the law enforcement officers pension system. The benefit would be a 100% line of duty disability for a catastrophic injury, and that would be an injury where the individual is not able to engage in any gainful activity. So these are, basically injuries where the individual is not going to be able to work anymore, whereas the existing line of duty disability, the standard is just you can't do your current job. So this is addressing the more serious incidents. The expectation is that there won't be any frequency of these, but for when they do happen, it would be addressing that. There are provisions in the bill updating the existing line of duty benefits to align them with this new benefit. The new benefit would require that it occurs in the actual performance of duty at a specific time and place. The First Amendment, that language was not included in one provision of the bill, so it's being added to make it consistent. There are also provisions where the individuals receiving this benefit are required to update the state retirement agency every year with tax and other information that the system requires to evaluate that the individual is in fact not engaging in any gainful activity, to sort of verify that this really is a 100% incapacity situation. And then the final amendment, which was not discussed at the subcommittee level but came up since it was voted out, was just the agency requested a clarifying provision that the act would apply prospectively to any accident that occurs after the effective date of the act. And then the bill also does have a 1-year delayed effect. The system is going to need time to develop regulations and processes to implement this.
Okay. Questions? All's in favor of the bill as amended? Aye. Opposed? This went through the committee, right?
So this came out of subcommittee with the exception of that prospective application clarification, which should have been the interpretation anyway, but the system just wanted to make it clear.
Senator Lewis Young. Yes, sir.
Mr. Chair, and just let everyone know that I appreciate the work we did in the subcommittee, but I appreciate everybody's work on this. Senator Jackson and I had worked on this for years, but I would like to point out the work that Ann and Philip did to help us to get this bill working with the state. And now it has been recognized that this bill in its condition, where it is right now, is potentially the example that the IRS is suggesting to all 50 states. Right, so for this situation. So I just wanted everyone to know that sometimes it takes us a little while to get things straight, but I really do appreciate what we've done with this bill, and I know that the officers, that have gone through such a tragic thing that they can never work again will be recognized for that. I appreciate it. Thank you.
Thank you, Senator. Appreciate your comments. All right, 654.
654, this is another pension bill. This came out of the subcommittee. There is one technical clarifying amendment. This bill would extend the mandatory retirement age in the state police retirement system from age 60 to age 62. The bill also does include provisions related to the DROP program. This is more or less boilerplate provisions you put whenever there's an extension of the amount of service somebody in these plans would drop can accumulate. Just clarifying that anyone currently in drop, to the extent the bill would allow them extra time in drop, they can apply for that. They'd still be subject to the general time limitations for participating in drop. The amendment is technical, just clarifying that with respect to that drop extension, it would be the earlier of the deadline in the bill or when their current drop period would run out.
Yes, sir.
So I actually had the opportunity, I heard this bill because I was at pensions that morning. I was curious. Ciola was against this bill. Are they supportive of the bill now as amended? Or does anyone know, did that change one way or another?
I don't know anything about that. I think some of the comments related to drop and people currently in drop may not have been accurate. Anyone currently in drop under the bill would be allowed to extend their participation subject to the general time limitations on drop.
Gotcha. I think that's an accurate representation. But do you know, have they been contacted back? Are they still the same position as they were previously, or do you not know?
I don't know that.
Yeah. I was just curious more than anything. I was just surprised that day that how they had said they hadn't really been.
I did. I talked to a couple of the folks, but they really, we haven't. What we talked about was the benefits of it, and of course working with the superintendent about the benefits of this and the challenges that we have, and that it was going to really help with the problems that they're having with the number of people who are retiring out and an opportunity to hold on while we're trying to rebuild the force.
No, no,
The
yeah,
benefits of it, but they still have, they expressed some concerns. They did.
Okay, I was just curious if those amendments rectified their concerns, but it sounds like probably
Not,
not.
I wouldn't say entirely.
Understood.
Yeah.
Fair enough.
Senator?
Thank you, Mr. Chair. And I could just clarify from working with Leola for so many years, this only affects a very few people, right? And it's only people that would have not taken advantage of the drop, right, for their full extent. So it would only affect people that really came to work later in life. So it's a very small portion. And the Leola's opposition to this was because they're worried about positions in grade for promotional opportunities. So when somebody hits 60, they were always ready for people to leave. And so this only affects a few people. I think the superintendent and his team made it clear this affects 8 or 10 people a year. They could really not lose that expertise right now. And that's why I supported the bill.
Okay. As amended, all those in favor of the bill? Aye. Opposed? Senator Lewis Young. 668.
$668 is a bill that would make some technical changes, renaming the Children's Interagency Cabinet Fund. The bill also would require the governor to include in the annual budget bill appropriations to the fund for the next 5 years. In fiscal 28, 3 million, and then in 27, 28, 29, and 32 million. However, the way those mandates work, it is on top of the yearly appropriation. So the first year would be 3 million. Above what the 27 budget was.
And what was that budget?
Let me see. Let's see. It is 20.3 million in the fiscal 27 budget. And so just to clarify, the way the amounts in the bill would work, it would be, in 28, 3 million, and then in 29, 2 million on top of the prior year's allocation. So they stack each year, the way the bill is written.
So, it's obviously good stuff that they work on. It's a pretty significant ongoing increase. What are the numbers again? I will, I'm going to offer that we amend this to 1,500,000, 500,000, 500,000. Excuse me?
Staying out of shall as well.
Yeah. Yeah. All those in favor of that amendment, say aye.
Aye.
Opposed? Okay, then as amended, the bill. All those in favor?
Aye.
Opposed? Okay. If you like. Okay. Anybody would like to sponsor, raise your hand. Yep. He's up.
So McCray, Augustine, Edelman, Gazoni, Zucker, and Lewis Young.
Yeah.
You're on it.
I'm already on it, right.
Yes.
Senator McCray. Love it when you love it. All right, let's see what this 704 is all about.
704, this is a bill dealing with estate taxes. So there is an exemption in, well, not exemption, there's a provision in the estate tax law that allows up to $5 million of an exemption for qualified agricultural property in law. And that is a requirement that it's real or personal property used primarily for farming purposes. And current law has a 5 million exemption, and then for any amount above that, the rate is 5%, so it's a lower rate. The provision requires that it be used, I believe it's for at least 10 years after the decedent's death. So the intent of the original provision was to try and keep property in farming and agricultural use. The bill would allow transfer of the property to a limited liability company, provided that the ownership of the limited liability company consists entirely of only qualified recipients. So I believe the intent is to be able to transfer it for, organizational, legal, tax purposes. But under current law, it's not clear that that's able.
For family or others?
So a qualified recipient is anyone who enters into an agreement to use the qualified property for farming purposes after the decedent's death. So if it ceases to be used for farming purposes, I believe after 10 years, there was a recapture provision. And so,
So the benefit is to
so right now,
those
it's
who are maybe taking over it,
yes.
even though they may not be. Are they heirs?
Yeah, they'd be the people,
They have to be an heir.
they would be receiving the property from the estate. So somebody dies, they leave it to somebody. I think generally, when you hear the testimony about it, it's about leaving it to family, but it could be anybody. To be a qualified recipient, it's an individual who enters an agreement to continue using it for agricultural purposes. But under the law as written, it's just an individual. So that if that individual were to transfer it to an LLC for whatever reason, the law is not clear, and it's possible the interpretation is that you would lose the exemption, be subject to the recapture provision for the estate taxes that would have been owed had the property not flowed through this exemption. So this would allow a transfer to an LLC, provided the ownership of the LLC are individuals who are qualified recipients. So if you leave it to a child, that child qualifies, agrees to use it as farm purposes, they're a qualified recipient, they could transfer it to an LLC that they own. If you leave it to two kids and they're both qualified recipients, they could both transfer it to an LLC that they both own. The Comptroller's Office did request a delayed implementation. I believe later this summer, they're migrating a lot of information to a new system, and they said that they would prefer pushing this back to be effective July 1, 2027. There is one other piece I wanted to bring to your attention. So the bill is written, typically when we do these, we draft them so that they're effective on a date and applicable to decedents dying on or after a date. That language is currently in there, but you may want to consider striking that because under that language, this change would only apply to property that passes from somebody dying after the effective date. And so with that language in there, it would likely be interpreted, or at least it would not be clear, that somebody who had already received property and is a qualified recipient would not have the same ability to make the transfer to an LLC as somebody receiving the property from somebody who dies after the effective date of the bill. So if you wanted to apply to anybody in this situation, you would just strike the reference to the decedents dying and just make the bill effective July 1, 2027.
I think I want to think about this one a little more. Somebody have any comments before we Okay, I'm gonna hold that one. 734,
We need to hold that one. I'm still waiting on some additional amendments.
okay. 748,
748 is a pension bill. This bill would authorize Allegheny County to move their corrections officers into the correctional officers retirement system, subject to them becoming a participating governmental unit. This is similar to legislation you already passed for Dorchester County.
okay.
And we
All
do have a
those in
local
favor?
Aye.
Opposed? Louis Young. Uh, 756.
All right. Senate Bill 756 authorizes Baltimore City to exempt or partially exempt an economic development project located in a downtown rise district from the city's real property tax. To qualify for the tax exemption, the owner of the property must conduct an economic analysis of the project and must enter into a payment in lieu of taxes agreement with the Baltimore City Board of Estimates. Bill also requires the city report to the president of the Baltimore City Council and the General Assembly a description of each economic development project for which the city has entered into a payment in lieu of taxes agreement during the preceding fiscal year, as well as additional information on completed projects. There is an amendment on this one. The amendment would make it an emergency bill and set the bill to sunset in 10 years. Just for a little bit of background, so for pilot agreements or payment in lieu of taxes agreements, that's where the property owner specifies a certain amount that the owner must pay to the city each year in lieu of property taxes. And to be eligible for a pilot agreement, the owner of the economic development project must apply to enter into a pilot agreement, have building permits issued, and have satisfied or waived all conditions for the financing required for the construction of the project. We do have a local letter for this one.
Okay. So we made this an emergency bill. We got an amendment. And you said we had a lot? Yeah. Okay. Everyone got this one? All those in favor? Aye. Opposed? Senator McCray? I can get a soda. I'll be right back.
Need some caffeine.
All right. 766 is a hold, waiting for an amendment. 818.
Okay. 818 establishes the State Center Advisory Group. You should have a reprint on your desk for the amendments on this one. On page, let me find it. On page 2 of the reprint, starting,
The sponsor amendment.
yeah. On page 2 of the
This is all
reprint,
just about how the group's going to work.
yeah. On page 2 of the reprint.
All those in favor as amended?
Aye.
Opposed?
There you go. Good job, man.
Prepared all this one.
Sir Stallings, you look like you need something to do. 828.
Senate Bill 828 would authorize the Central Collection Unit in Budget and Management in consultation with the Attorney General to collect federal funds owed to the state, place liens on federal property in the state, and direct the comptroller to withhold payments to the federal government if BPW determines the federal government to be delinquent in federal funds owed to the state.
So what are we holding back if the federal government is delinquent?
Correct. If the federal government is delinquent in funds owed to the state, it would authorize the Central Collection Unit to collect those funds. It is subject.
Aren't they already authorized to collect those funds?
I'm not entirely sure.
Okay.
But this would be making it clear.
Yep.
It would be subject to a situation when the federal government's not complying with a court decision. The Board of Public Works may determine by majority vote the federal government to be delinquent, and then federal funds determined under that process would be referred to central collections.
Yeah.
There's authorization to place liens on federal property, and also for the comptroller to withhold payments to the federal government related to any delinquent funds. So it's authorizing
Yeah.
and creating a process by which
Okay.
to exercise that authority.
All right, any questions? All those in favor? Aye. Opposed? Senator Augustine?
Aye, sorry.
No, you've got the bill now. We got the vote?
Yep.
8:33.
That's 4, Kevin.
Okay. Thank you.
Man, what a ranking number, really. That's we just watched that, folks.
Senate Bill 833 is a local bill that authorizes Queens Anne's County Commissioners to use the revenue from a development impact fee to finance any capital costs related to the replacement of public school facilities. We have a letter of support from the delegation.
It's only one person.
Yeah.
And they all agreed.
And he's a sponsor, yeah.
All those in favor? Opposed? Senator Salling? You might just get all of these rest of these, Senator Salling. You've been too quiet over there. 847.
Senate Bill 847, it's another local bill, authorizes Wycomico County and municipalities in the county to grant by law a property tax credit for real property that is owned by Salisbury Neighborhood Housing Services with the intention of relinquishing ownership in the near future, is used for the purposes of development, rehabilitation, and transfer to a private owner and not occupied by administrative or warehouse buildings owned by Salisbury Neighborhood Housing Services. County and municipal governments may provide for the amount, terms, scopes, and duration of the tax credit.
All those in favor? Opposed? You're welcome. 851.
Is that what's all in them? 851, another local bill, authorizes Anne Arundel County to grant by law a property tax credit for real property that is located in a specified rural legacy area and for which the property owner has sold the development rights under the Rural Legacy Program. We have a local letter.
All those in favor? Aye. Opposed? You got it. That is going to conclude our voting for today. Yes, sir.
Since I've been fed so well,
Yes.
and I'd like to look at 980, a local bill, if you don't mind.
Oh, sure. What do we got? All right, well, we'll take a minute. We'll find it.
Thank you, sir.
Sure. Yeah. you get a report from it? Whose bill was it? It's Matt's. No, I mean, it's Matt's.
Oh, sorry.
He's got me back.
Are you, like, some type of 5-year or some type of sunset, I'd be able to get that report and be able to look at what they're doing?
Sure.
Okay.
So, before we do that, we're going back to 85. And it sounds like we want to get an amendment for a report. Senator McCray, you seems to have an idea of exactly what that might look like.
You know, I just think of like a 5-year sunset, so that way we can actually review the report that come out and understand how these dollars are being dispersed.
Okay, for, under their new authorization?
Yeah.
Okay.
Do you want an annual report?
Well, it could be an annual report, but I do think, yeah.
I'd like the annual report, pays the sunset.
Okay, annual report, just ongoing?
On the fund, how they're, this is
Yeah.
700 some thousand, yeah, how they're spending it,
Okay,
please.
Well, for 5-year sunset,
on the report, or on the whole thing?
yeah.
Whole thing?
Yes, sir.
Okay.
Okay. All's in favor of that report?
Aye.
Opposed? Okay. Whatever. Well, we can talk about it. I thought it was a local bill. I thought it was your local bill. But we can talk about it. But we need to, he hadn't reviewed it yet. When did we hear this?
I think yesterday.
We just heard it yesterday, right? Yeah, yeah. We'll get to it, and we'll get to it before crossover. Okay? Got that, Matt?
Got it.
All right, I think that's it for this today.